Well, thank you very much, Chairman, Director of the Latvian Intellectual Property Office. Ladies and gentlemen, it's a pleasure for me to have been invited back to this seminar of judges from your beautiful country. After the flamboyant speech of Judge Feisch, I'm not so sure whether I will be able to give you similar entertainment or information. Nevertheless, I will try to stay within the time limit that will allow you to go to lunch in due time, so I will probably speed up a little bit my presentation. What am I doing? I've been invited here to talk to you about case law in the field of trademarks that has been developed by the courts in Luxembourg. Of course, you are familiar with the jurisdiction of the court in Luxembourg. They deal with what are called preliminary rulings. The legal basis is Article 267 of the Treaty on the Functioning of the European Union. That's one way where a national court, which needs an interpretation of European Union law to decide a case, and where that legal issue has not yet been clarified by previous case law, the court of last resort is obliged to make a reference to the Court of Justice. Lower courts are entitled to do so. And a number of cases that I'm going to present to you today have come to the Court of Justice by way of this preliminary ruling procedure. The other way of getting cases to the Court of Justice is through the appeal procedure. A case begins in the European Union Intellectual Property Office. Alicante goes to their boards of appeal, and the decisions of the Board of Appeal are appealable to the General Court in first instance, and on points of law to the Court of Justice. That is the other approach in which European Union trademark law has been developed over the years, including in the preceding year. Just a short remark on an institutional issue. The Court of Justice has adopted, as from the 1st of May this year, a new procedure when an appeal is brought from a decision of the General Court that has come to the General Court from the EU IPO. In these situations now, an appellant must submit a separate brief of no more than 7 pages setting out why the appeal should be accepted by the Court of Justice. There is no longer an absolute right of appealing any case to the Court of Justice, but the Court of Justice now has a procedure where it will look at the brief of 7 pages, which has to be filed in addition to the appeal itself, and decide whether it will accept the appeal. It can reject this with a reasoned order. The idea there is that the Court of Justice has found out that very many of these cases are rather repetitive and don't present truly relevant issues of law for the development of European Union law. Also, you've had already 3 instances deciding the case: the office itself, the boards of appeal, and the General Court. So that is the reason why this procedure has been instituted. You may also find increasingly cases from the Court of Justice which do not identify the parties. This is the issue of anonymity, of not disclosing the identity of parties in the procedure. The Court of Justice has so far been very generous in disclosing who is the applicant, who is the other party, who are the lawyers, but that may in future change somewhat. If you look at numbers, in the year 2018, the Court of Justice had 5 preliminary rulings, and on decisions from the General Court on appeal, 39 cases, of which 16 were judgments and 23 were orders. Orders are abbreviated procedure where, without a hearing, usually the application is dismissed. These are significant figures for a court of last resort. 39 plus 5 cases in 2018. If you look at cases in this year, from January to August, we've had 4 preliminary rulings. We have already had 32 cases in the Court of Justice, of which are 9 judgments and 23 orders. So again, it's a significant number of cases. I cannot, of course, present all of them, but what I have for you today is a selection. In the background, you have to see that every year about 150,000 applications are currently filed in trademark cases in the office in Alicante. Each year we have about close to 20,000 opposition proceedings. If you compare that with opposition proceedings in your country, you will see this is a multiple by many times over. There are about 6,700 opposition division decisions which are appealable to the boards of appeal. About 2,600 new decisions of the boards of appeal. That is the universe from which the cases then go to the General Court and the Court of Justice. So what I will talk about is essentially issues of substantive law. I will begin with a few cases on what we call absolute exclusions. These are signs which are not registrable regardless of how distinctive they are. And as you are familiar with the law, this is the definition of the trademark now in Article 4 of the trademark regulation. It has, the law has changed because the requirement for graphic representation has disappeared. And you find this, that's the old law. And you have the absolute exclusions, which are in Article 7 of the regulation. And in Article 4 of the Trademark Directive from 2015, what used to be exclusions of shapes is now extended to other characteristics of the products. And we are beginning to see initial cases involving the amendment of the directive and of the regulation, not yet anything final, by no means. In March this year, the Court of Justice was faced with this case. This is a representation of Manhattan. This is why this case is also called Manhattan. It is a figurative trademark, and you can imagine that it is applied to tapestry or to a towel or to some other piece of cloth. And the issue that was raised, the case came to the Court of Justice from the Swedish court, was whether this is a sign which would fall under this category, the sign, not the shape, but another characteristic which results from the nature of the goods themselves, and specifically which gives substantial value to the goods. And so the first thing that the court had to decide, is this a sign consisting exclusively of a shape? That is the old law, and of course that's easy to decide. No, this is a two-dimensional sign which can be applied to a shape or to a piece of paper or wallpaper, whatever it is. So it's not a shape and therefore rather easy to judge under the preceding law. The issue that came up in the discussion was whether the new law, which I described, any other characteristic, would also be applicable to trademarks which had been filed before the coming into force of the new law. The directive was adopted in December 2015, and I'm sure in your country the law has been adapted to the directive because the last time was in the 15th of January this year. Not yet. Not yet. It will be adapted in due time when your parliament has time to deal with trademark law. I'm sure it has nothing to do with the office or preparing the legislation. You are one of the very few countries where that is still lacking, the transposition of the directive. Anyway, the question was asked, is this new provision applicable to trademarks which have a filing date prior to the new law? And the answer is no, it's not. It's not. This is a law which is applicable only to trademarks. Now, question registered or filed prior to the coming into force, and the office in Alicante is applying this to the new law only to trademarks which have a filing date after the coming into force of the new regulation, which, by the way, for the office in Alicante was in October 2017. So next case is this one. It's a case that came from Finland. It's called Heartwall. And if you look at this sign, you will see that this is a classic figurative trademark, blue with a gray border. It was applied for mineral water, and you can imagine it is a label that is put on a bottle. The applicant, however, said this is a color trademark. Color trademarks are trademarks which are indicated as colors, are reproduced by reproducing the color, but they are trademarks without contour, they're abstract color trademarks. And here the question was, what happens in the case where the trademark, when you look at it, is not a color trademark, but the applicant insists this is a color trademark. And we are back at my early definition of registrable trademarks being represented on the register in a manner which enables the competent authorities and the public to determine the clear and precise subject matter of the protection afforded. So the issue is, what happens if there's a discrepancy between trademark as represented and as indicated in the application? And the court came to the conclusion it does not comply with the definition of a trademark because it is no longer to be identified clearly what the applicant actually wants. Consequence, the trademark must be rejected. Now, in practice, an office would normally invite the party to make a correction and to bring its application in line with what the mark shows. In this particular instance, apparently the applicant was insisting that it is a color trademark, although it looked totally different. The consequence is he will not get a trademark unless the Finnish authorities, even at this late stage, will allow him to get a trademark. Colors. You're familiar with the product. This is Red Bull. They are using on basically all of their packaging a blue and silver combination. And here there are two trademarks involved. One is described as approximately 50%. And the second trademark is described, the two colors will be applied in equal proportion and juxtaposed to each other. And the issue there was, in effect, quite similar to the issue that the court had to deal with in the Heartwall case. You have a trademark showing two colors, and you have a description. And when the description and the colors as they are shown are compared with each other, the court concluded there are so many variations in which you can apply this color combination at 50-50 or in this way juxtaposed to each other, that the trademark does not comply with the requirement of definiteness. A trademark must be specific and definite in order to allow, or clear, precise, whichever language you want to use, so that the public will understand what the trademark actually consists of. And since there are multiple ways of presenting these colors on a finished product, this trademark was refused as failing the definition of clarity and precision. I have a number of considerations out of the judgment that the Court of Justice did in this case for you to look at, but the essential message is that for a color trademark consisting of two or more colors, do not have a description which allows a use of that color in too many variations or in any variations. And the message that you get from the office in Alicante is, if you file a color combination trademark, do not add a description which causes the whole trademark to be indefinite. The next issue on absolute grounds is the issue of distinctiveness and descriptiveness. And I have reproduced here the text of Article 7 of the European Union Trademark Regulation, which corresponds essentially to Article 4 of the directive. And I have given a short definition of distinctiveness, which you can look at if you have time to look at my slides. And we have descriptiveness. These usually overlap substantially. And I have two cases which are relevant in this context. The Birkenstock case decided in September last year shows a pattern. It is filed as a figurative trademark, and the office refused it, and the Boards of Appeal refused it, and the General Court refused it, and the Court of Justice refused it, because they said this is a pattern which can be applied to the surface of a product, for example, the sole of a shoe. And as it repeats itself in this manner, when used as a surface pattern in this way, it is not distinctive. Why? Because it is nothing more than a simple surface pattern. It doesn't display any kind of anything which the normal public would identify as indicating commercial origin. So what did the applicant say? The applicant said, this is a figurative trademark. It is not a surface pattern at all. And the issue that the court had to decide is it likely that the applicant will use this figurative trademark as a surface pattern, and then it is not distinctive? Or do you follow the argument of the applicant, well, how do you know that I will use this as the surface pattern for shoe soles or anything else? I might just use it as a label, as a figurative trademark, and then it is sufficiently distinctive. So here we are in an issue of evidence and arguments, and in the end, the Court of Justice confirmed that the General Court was right in considering a plausible, a normal way of using this, namely as a surface pattern, and therefore the trademark was correctly refused. The argument of the applicant that he might also use it in a manner in which it was distinctive was not accepted. Kind of complicated, correctly used the criterion of the possible, not unlikely use of that particular sign. So now we have the reverse situation, a reference from the German Federal Supreme Court, which was decided 2 weeks ago, a little bit more than 2 weeks ago. Is it? Yeah, 1920, no, less than 2 weeks ago. The trademark is called Hashmark Darf das. Darf das means, is he allowed to do that? And the argument that the office, this is the German Patent Office made, German Patent and Trademark Office made, was this is a slogan, this is not a trademark, so therefore not distinctive under rules which are applied to promotional terms or what we call slogans. So, but the applicant said, I'm sorry, I don't want to use it as a slogan, I want to use it as a trademark. And this is for clothing, class 25. He said, well, I want to put it on, I don't want to put it on the front of a t-shirt where it is a slogan, I want to put it on the label in the shirt, and then obviously it can function as a trademark because it is not descriptive, and it can be used in a manner as a trademark. So the German Supreme Court asked the question to the Court of Justice, does a sign have distinctive character when there are in practice significant and obvious possibilities for it to be used as an indication of origin? So the question is in a way similar to the Birkenstock question, but in the reverse order, because here the issue is, are there plausible or reasonable manners in which a particular sign may be used as a trademark. And if these exist, and if under this hypothesis the trademark is distinctive, it should be accepted, question mark. So that came back from the Court of Justice. Anything which is practically significant, now unless you have, this is a mark which hasn't been used, so you must make presumptions about how it is likely to be used in the absence of other indications to the types of use which in the light of the customs in the economic sector concerned, he would talk about clothing, can be practically significant. Consequence is that, somewhat different from the Birkenstock case, if a trademark can be used as an indication of origin on a particular product, and in that manner of use would be distinctive, there is no basis for refusing registration. You're familiar that a trademark which is not distinctive ab initio, inherently distinctive, or which is descriptive, may be registered if it has acquired distinctiveness. That is the basis which I have indicated. It has become distinctive as a consequence of the use which has been made of it. Question there is, what must be used, the sign, the mark, how must it be used as a mark, who must recognize the sign, the relevant parts of the public, and the issue for European Union trademarks, particularly complicated, where must the sign have been used to acquire distinctiveness, and that is the European Union as a whole. A recent case came to the General Court, decided a few months ago, involving this trademark. This is a figurative trademark filed by Adidas. It was judged to be not inherently distinctive, and the principal issue was, did it acquire distinctiveness through use? So the mark was identified in the register. The mark consists of 3 parallel equidistant stripes of identical width applied on the product in any direction. Figurative trademark, not a position mark. And the issue came up, how do I show acquired distinctiveness for a mark which looks like this? For example, if you reverse black and white, so you have 3 white on a black background. If you change the direction, if you change the proportion, are these permissible variations when you prove acquired distinctiveness? The General Court applied a rule which we are familiar with from use cases. You can use a trademark which differs from the form in which it is registered if these variations are minor, or if they do not, as it's said in the law, alter the distinctive character of the mark as registered. And they apply the same criterion here. And then if you look at examples which Adidas presented to the courts, there are various ways, as you can easily see, there is white and black, and lengthwise, and in colors, and on shoes, and so on. And the court dismissed all of these examples because it said this is not the trademark as registered in the dimensions that it was applied for, and these are variations which alter the distinctive character of the trademark. So what in the end was the outcome, Adidas was not able to show acquired distinctiveness for its 3 stripe marks in the European Union. There were also market surveys. These market surveys covered only 5 member states. And there is case law in the Court of Justice, and I think I mentioned it last year here, called the Kit Kat case, where the Court of Justice says you have to have acquired distinctiveness essentially everywhere in the European Union in order to get protection for a mark on the basis of acquired distinctiveness. Likelihood of confusion is the standard for testing most trademark conflicts. Of course, there is a double identity when the mark and the goods in both directions are identical. These cases arise very rarely in the Court of Justice anymore. And you have marks with a reputation where you do not have to have even similarity of the goods and services. But the few cases that I'm going to show you are neither reputation cases nor double identity, but the likelihood of confusion case. These are the applicable rules. This is a very recent case coming from the Court of Justice involving an earlier mark which is called Röslagspunsch and a later mark which is called Röslagsöl. I'm sure you are not sufficiently familiar with Swedish geography. Somewhere north of Stockholm is a small region which is called Röslags. So you have a geographic name plus a product name, in the case of the earlier mark, plus some figurative elements. The Swedish office applies the same principle that is also applied in many other countries, namely you examine a later trademark for conflict with an earlier trademark ex officio. You don't need an opposition procedure. The office itself looks up in its register, are there similar trademarks? And here they find Röslagsöl, by the way, öl in Swedish means beer. So these are similar products in the same class. This picture, by the way, is not from the case. I just want to show you that this actually exists in real life, Röslagsöl. What was the particular issue? Röslags, as a geographic name, had been disclaimed in the earlier registration. Under Swedish law, there is a so-called disclaimer. A person may say, I do not claim any exclusive rights to a term, in this case, Röslags, because it's geographic. And the issue that the court had to decide was whether in this confrontation of these two trademarks, which the office examined ex officio, what happens with a term that has been disclaimed, Röslags? Or you could also more in the abstract ask, you have two trademarks which coincide with a geographic name, which would not itself be registrable because it's a geographic name. And the reference came from the Swedish court, which asked the question, how do I deal this disclaimer issue? Do I simply disregard the element, Röslags, when I compare the two trademarks, and then, of course, they are not in conflict? Do I give it less weight because there is a disclaimer? Or do I examine the trademarks like I examine any other trademark without looking at the disclaimer as an element involved? And not surprisingly, the Court of Justice said you follow the third approach. You must compare the trademarks as if there was no disclaimer. They say this because they say there's a general rule on examining likelihood of confusion, which requires you to take into account all circumstances, all relevant circumstances of the case, including the degree of distinctiveness of the elements if they are composite trademarks. But, of course, the public has absolutely no idea about whether there is a disclaimer or not. You always do this with a view of deciding whether the public to which the trademarks are addressed will be likely to be confused about the commercial origin of the signs. Consequence is that you examine these trademarks, Röslagspunsch and Röslagsöl, under normal standards, and the normal standard will allow you to consider an element which is non-distinctive as part of the earlier mark, and of the later mark you may give it less weight or even no weight in the comparison, but you don't do this because of the disclaimer, but because it's geographic. It's a weak or even non-distinctive element in the conflicting trademarks. Infringement. We have an interesting case coming from Germany, Ökotest. That is a label used by a publication which does testing of the ecological relevance of a product, and they allow companies to use the results of this testing. I mean, there are many of these kind of publications in the world on their products as part of their labeling. Mr. Liebe, on the right side, had previously been authorized to use the Sehr gut Ökotest label on a predecessor of this particular product, but not for this one. So he was using this on a product which actually had not been tested. And the publisher of the Ökotest magazine brought an action for infringement against Dr. Liebe. And if you look what the mark was registered for, printed matter, which is the publication, services consisting in conducting tests and providing consumers. So question, is that mark registered for these services infringed by someone using the mark for toothpaste? And obviously, this is not the case. Why? Because under standard analysis, the mark may be identical, but the goods are not identical because toothpaste has nothing to do with testing. The marks are not still identical, but the goods are not similar. So you also have no likelihood of confusion. However, the plaintiff could prevail under the reputation analysis, which was an issue, question of proof. Is your journal Ökotest so famous that someone uses it for toothpaste without authority infringing or not? Now, the obvious answer under new law is that Ökotest should get a certification trademark, because then it can certify the quality or characteristics of goods and could register the certification mark for those goods, and then you would get an easier infringement situation. I have another infringement case in the broadest sense, which you may not have seen previously because it arose under design law. In design law, an earlier trademark may be the basis for an invalidation action against the later design if the design contains or consists of a distinctive sign which under the applicable law gives the owner of the distinctive sign the right to prohibit the use of the later design. So here we have an earlier trademark on the left side, a later design on the right side, and the question you ask is, if the design on the right side is used, would that constitute an infringement of the earlier black and white trademark? And quite surprisingly, at all instances, it was said, yes, the mark on the left prevails over the design on the right. It is the first time that two 3D marks or signs have been at the Court of Justice, and quite surprisingly, a very broad scope of protection for the earlier three-dimensional trademark. Chairman, tell me how many more minutes do I have?
Still at least 15, 20.
15, okay. I don't want to eat into your eating time, okay?
Don't worry about it.
Yes, please.
Just one question regarding the previous case.
Did you
What
okay?
is your opinion on that? Because
This one? Did you
the
okay?
previous one about the three-dimensional.
Ah, this one.
Yeah. What is your personal opinion on that? Because it seems a bit not really. Well, design is not the same. Really, the can itself.
So you have to use the microphone? I'm sorry, Judge.
Yes,
I
sorry.
understood.
What is your personal opinion on that? Would you really see there? Because if we look at that just from the design law perspective, I wouldn't say that the can itself, disregarding all colors and everything, but just the can itself is the same.
So the standard is really a trademark standard rather than a design standard, because Article 25, 1 so-and-so of the design regulation, which I have reproduced here, this is the legal basis. if a distinctive sign is used in a subsequent design and confers on the right holder the right to prohibit such use. So it's a classic trademark question that you have to answer. And my own reading under trademark law is that these signs are not similar enough to create likelihood of confusion. Why? What is the difference? The color, the shape, you cannot simply assume that the containers on the right don't have any color. They are in color. Also, the shape is somewhat different. If you look at this is much more rounded and square. So I think it's a curious decision, and we will see what happens to it. It is interesting that how does all of this arise at the Court of Justice? The Court of Justice only examines whether the courts below have committed an error of law. And this is what the General Court said. The fact that the design is represented filled with sweets cannot constitute a relevant point of visual comparison, since the contested design is registered merely for the box or container of those sweets. And that it is clear that the earlier international registration was also registered for filling with sweets. How does the court know this? We don't know this. They know it's because it's Ferrero. And Ferrero is filling these containers with sweets. Now, this reading of the General Court is taken by the Court of Justice as a statement of fact. So they cannot reverse it, or they don't want to reverse it. They could have if they had understood that they're creating precedent in the conflicts between three-dimensional trademarks, which is quite unusual. But it's part of this exercise. That's what the Court of Justice said. The applicant seeks to obtain a fresh appraisal of the General Court's assessment of the facts relating to the visual, phonetic, and conceptual similarity of the signs at issue, which does not, save where the facts have been distorted, constitute a question of law, which the Court of Justice is entitled to judge. So, answer, you have a finding of fact on the comparison, which the Court of Justice leaves alone. A court for example, in Germany, the German Federal Supreme Court considers itself entitled to review these points because they say likelihood of confusion in the end is a question of law. In the end. There are elements of it which are factual, but it is, in the end, the question, which rights do I give to the owner of an earlier trademark? Scope of protection. And it's not exclusively an issue of fact. But the Court of Justice sees this different, and this is where we have to move forward from. Bad faith. There are two cases on bad faith which I have. Bad faith is a ground for refusing or opposition in those countries which have this as an opposition ground or an absolute grounds of refusal. In the European Union system, bad faith is a ground for invalidity, absolute invalidity ground, which may be invoked only after registration. The case came up about 2 weeks ago, decided again by the Court of Justice, involving a rather simple question. If you rely on bad faith against the trademark which is registered at the EU IPO, is it necessary that you have yourself an earlier trademark for identical or similar goods? And the answer, I would have thought, is so obvious that bad faith has nothing to do with you having yourself a European Union trademark for identical goods or services, that it's strange that it took 3 instances, because the wrong decision was already done by the Board of Appeal. You need a trademark in order to invoke bad faith. The General Court confirmed this, and then the case came to the Court of Justice, and the EU IPO itself said that's a bad decision. Please, Court of Justice, reverse it. we are willing to pay the costs of that. And not surprisingly, the Court of Justice in this decision said the bad faith is an analysis of all the circumstances in the particular case, which allow you to conclude that the conduct of the person who is accused of having a bad faith application is contrary to accepted business morals, commercial morals. It must be evidenced by objective circumstances, because you cannot, in a way, have the applicant testifying in his own behalf about his individual feelings at the time he was filing, but it is the subjective intent manifested by objective criteria. And here the case is merely clarified that the fact that there is no registration for identical or similar goods on the part of the applicant is not an obstacle to finding bad faith. I just recommend this to you as reading how the Court of Justice deals with these things. It's a more interesting case, perhaps. You know who Mr. Neymar is? Yeah, Mr. Neymar is a Brazilian football star who in the year 2012 came from Brazil to FC Barcelona. Then, of course, he is now for PSG in Paris. Someone filed the trademark Neymar in 2012, Mr. M. And the question was, did he act in bad faith? And he made all kinds of strange things and remarks, family name or something like it. He acknowledges he knew of Neymar, but contends he did not know he would become an international football player. Now, there's evidence to the contrary in the file, and it wasn't very difficult for the General Court to hold that the applicant had acted in bad faith. I have 2 or 3 genuine use cases decided by the Court of Justice. Genuine use arises as a ground for revocation. After 5 years of non-use, a registered trademark may be revoked. Non-use arises as a defense in an opposition proceedings, defense in invalidity proceedings, and a defense in infringement proceedings. And this is the basic rule in the European Union trademark regulation. You now have in Article 16 of the directive a very similar provision. And I'm sure that in your system, implementing these new provisions in the directive will cause problems, because you need opposition and defense of non-use in opposition proceedings. You need an administrative revocation proceedings for non-use, and you need the defense of non-use in invalidity proceedings and also in infringement proceedings. What are the basic issues on use? Who must use the trademark? It is always the proprietor or with his consent. What must be used? The trademark or an acceptable variation. What must the mark be used for the goods or services for which the mark is registered? Very important. And where must the mark be used in the European Union? The use must be in the European Union. For the member states, it must be in the respective member state. When the mark is subject to sanctions, if it has not been used for an uninterrupted period of 5 years, this is the grace period. Initial grace period is calculated from the date of registration, and the use must be genuine in time, in place, and extent, in volume. All circumstances are taken into account. There's a case decided earlier this year involving the trademark Cystis. Cystis is a plant, and the plant provides the ingredient to a number of medications or food supplements. I have here reproduced this, by the way, comes actually from the owner of the mark, Cystis, and he adds Cystis 052 with an R to it. The question is, if you use Cystis and you have a registration for Cystis, is this genuine use of Cystis as a trademark? Now, it is registered for food supplements, not for medical purposes. the cancellation applicant claimed that the mark is not used as a trademark, it is used as a descriptive indication of an ingredient. The product contains extracts from the plant cistus. And in the end, the courts agreed with this, and the cistus trademark was cancelled because it wasn't used as a trademark. It was used as an indication of an ingredient, which in the end everyone should be allowed to do. My second use case is this one. Again, if you go to the case, as I've indicated, you don't find the pictures. The pictures come from the website of EU IPO and some earlier decisions. The case itself is just a description of what the legal rules are. You have at the left, it's a stove, iron stove for heating, and on the right, the same stove as actually on the market. And where's the difference? You see a name here, a name. Whereas in the original ones as registered, they have no name. And the question that presented itself, does adding the name of the producer on the stove alter the distinctive character of the three-dimensional trademark as registered? And it is quite surprising. I don't really have this here. It is quite surprising that it took a number of years for this case finally to be settled. The case came up from the office, and they said, yes, it's sufficient use. The board said sufficient use. The general court said sufficient use. Came to the Court of Justice. There was a procedural problem. It went back down to the general court, decided again, and then finally in January of this year, Mr. Clement lost his many appeals. A three-dimensional, this is in German, I'm sorry. It doesn't exist in English, it doesn't exist in another language, maybe it would exist in Latvian. If you go to the website of the Court of Justice, on the day the case appears on the website, you usually have it in all languages. Now, currently, they have a problem in providing English and German translations because they may not have enough translators. But I'm sure that if you go there, you actually will find it in Latvian. Sorry, I didn't reproduce it in your own language. Next case is an interesting one. Involves the trademark Boswellan. I just reproduce a product which contains Boswellian. I don't know whether you're familiar with that product. It is called in English frankincense. And it's actually the stuff that the three kings from the Orient brought to the baby Jesus. Gold and myrrh, well, frankincense. And frankincense is burnt in churches, and it's become a very new age type medication or quasi-medication. So what happened in that particular case is the mark was registered 2007, revocation 2013, so you are after the 5 years. And the owner of the mark said, well, I have been using it in clinical tests. Trademark for medication needs to have clinical testing before it gets market authorization. So question that arose, is use of a trademark in clinical tests sufficient to amount to genuine use? And second question, if it is not sufficient to amount to genuine use, is the fact that the mark has been used in clinical tests sufficient to argue there are good reasons, justified reasons, to defend the non-use? Presence of justified reasons. Proper reasons is the language used in the directive and in the regulation. And quite surprisingly, all the courts came to the conclusion that, including the office in its initial analysis, that the use in clinical testing is not use of the trademark. I'm sure that this will not be welcome news for the pharmaceutical industry, who very often file trademarks at a point in time when they are not yet on the market in order to have protection, and who may need more than the 3-5 years, whatever it takes for the clinical testing, use in clinical testing is not genuine use. And secondly, you can also not invoke justified reasons. Why? Because it is in the hands of the proprietor himself. When does he begin with the testing and so on? So this is not entirely independent of his will, which is the legal rule to be applied. I have the Coffee-Mail case, but I will not deal with it because Mrs. Schöner will later deal with the copyright case, but it's actually also from our field. And I will end with a message on jurisdiction. You may be familiar, and I'm sure you are familiar, that in order to bring an infringement action on the basis of a European Union trademark, you have a number of locations where you can bring that case. In the domicile of the defendant, if you want European Union-wide protection, if the defendant has a domicile or establishment in the European Union, if the defendant does not have domicile or establishment in the European Union, you sue at your own domicile or establishment, plaintiff. And if none of their European Union-wide, you go to the courts in Alicante. And then there is the final one, which reads like this. May be brought in the courts of the member state in which the act of infringement has been committed or threatened. And the question is, when all of this happens in a single member state, it's very easy. But the case that arose for this judgment called AMS Neve was a Spanish defendant who operated a website in Spain, which was in English and which was accessible in England and which presented products which were available in the English market. The website was operated in Spain, the operator was in Spain, but the website was directed at the English public. And the question that was presented to the court is exactly this one. Where are the acts of infringement committed, or where are they threatened? Are they committed or threatened in Spain, where the website is operated? Or are they committed or threatened in England, where the products are offered for sale? Why did this case become relevant? Not too long ago, a German court had said in a situation like this, the only place where you can sue under this criterion is where the website is operated. The Court of Appeal in England thought that that was a very bad answer and referred the question to the Court of Justice. This is the question. Where can you bring a case under these circumstances which I described? And the Court of Justice very sensibly answered, again, this is only about 3 weeks ago, that you can bring a case in England under the circumstances which I described. Website in English, offering goods for sale in England. You do not have to go to Spain. You can sue in England. However, you have to be aware that this is a case where the jurisdiction of the court in England, as the jurisdiction in the place where acts of infringement have been committed or are threatened, is limited to the United Kingdom. Very welcome addition to the case law, and that's it for today. Thank you.
To thank the Professor Dr. von Mühlendahl for this eloquent insight into the most recent case law of the European Court of Justice and General Court. Un, protams, jautājums audiencei varbūt, kā saka, šī runa ir kādam radījusi jautājumu, pārdomas, kur jūs gribētu kaut ko noskaidroši.
Regarding Adidas case, that claimant has to prove the acquired distinctiveness throughout the EU, would that mean in each of 28 countries or majority of those countries?
The answer is in all of them. those of you who were here last year may remember that I presented the so-called Kit Kat case, which had exactly that issue. Kit Kat is a product made by Nestle, quite well known, and the protection claimed was not for the name but for the shape. And in that case, they had presented surveys or evidence from 15 countries and made the argument that this was enough. It's a predominant part of the European Union. And the Court of Justice said, no, that's the wrong criterion. You have to show it for all of the European Union, which means for each member state. As regards the evidence, there may be manners of showing acquired distinctiveness in a particular member state by extrapolating from evidence from another member state. For example, if you have a German survey which shows that a significant part of the German public knows that this is a trademark, and you have a similar market presence in Austria, the public is very similar, you may not have to bring additional survey evidence for Austria, extrapolation. The underlying argument is quite simple. A trademark which would not be registrable in a member state because it is not distinctive in a member state precludes protection as a European Union trademark because it is valid everywhere. And the legal basis on which you base is the following. A trademark may not be registered if a ground for refusal exists in a part of the European Union only. If you have an earlier trademark in one member state, you cannot get European Union trademark. You can get national trademark, but not European Union. And they kind of use the same argument. If you cannot get a trademark in one member state because it's not distinctive there, you cannot get a European Union trademark. It's harsh, it's a strict rule, but it will be welcome news for many national officers because the only way of then getting protection for this trademark is going the national route, which is happening. So Nestle, for its Kit Kat, will get protection wherever they are able to show acquired distinctiveness, which will be more or less sufficient to keep competitors from the market anyway. But they cannot go the route through Alicante. They have to go national.
Vai kādam ir vēl kādi jautājumi?